They're in contract. They're in contracts. You have to have a contract. You have to pay the contract. So what we're doing is when we're writing someone, let's say when you're discharging a debt, okay, and you need to think about UCC 3-603B, all right, which tender a payment, okay? The reason you have a UCC 3-603B because there isn't any money. Because if they will not accept a negotiable instrument, there is nothing else that you can give someone to satisfy a debt, all right? Because everything that's operating in this system is a negotiable instrument. Federal Reserve notes are negotiable instruments. Bills of exchange, promissory notes, the bonds, these are all debt instruments. These are all evidences of debt. These are all IOUs. And no way can they be actual payment of an obligation. All right, payment. So this is why we're using accounting or money of account, and we're doing accounting procedures and where we're offsetting debt with one obligation with another obligation. If you owe me $500 and then you come and I come over your house and knock over your lamp, and it was a $500 lamp, now I owe you $500. All right, now we can set off. That's what we're doing with the federal government. Getting off. We're not paying anything. The federal government is bankrupt. They're over 30. They took gold from the American people, so they owe a debt to us. We're using the value of that debt that they owe to us in the private, all right, and utilizing the straw man as a transmitting utility, a bridge, if you will, from the private into the public, and using private credit to offset public obligation by utilizing our signature as the authorized representative for the straw man. Damn, I can't even see it. Okay, I don't know if I can't see nothing. But anyway, I wanted to just drop that on you real quick. I'm not going to talk long today. I wish I want to answer questions, but I'm driving. I can't really answer any questions right now. Perhaps we can get in some Q&A later. But I wanted to drop this on you that your rights are in contract. Letters are contract. When you do an administrative process, you're creating a contract situation, and now you're going to go into a court of equity to enforce that contract. Equity is fairness, impartiality, and even-handed dealing. And remember, the creator of the balanced universe judges you with equity. Peace to the guys. I'll catch y'all on the next one. Discharge all debts dollar for dollar. Okay, this is the secret that they don't want anybody to know, based off the fact that they took the gold out of circulation in 1933. Now, this really wasn't for private citizens. This was only for people in the public. The government had no authority. And this is why it's important that you understand the distinction between public and private. Because if you had a finely tuned understanding of that, you would know that no executive order could require private citizens to turn over their gold. So they're looking at it that you did it kind of voluntarily, though they'll never probably admit that. But in order for this to not be a fraud committed against the American people, they had to give you something in return. This is like what a constructive trust is, constructive trust and equity. So that gold is being held in trust, and there has to be an expectation of return of that gold to the American people. Instead of the return of that gold, they have allowed us to discharge our debts and obligations utilizing private commercial script, otherwise known as Federal Reserve notes. Now, these Federal Reserve notes, of course, are operating in a private jurisdiction. A lot of people will tell you that Federal Reserve notes are unconstitutional. This is due to the fact of their lack of understanding of how the Constitution is put together. Okay, this is a territorial jurisdiction. Federal Reserve is operating in a territorial jurisdiction. All right, and that's why you have a federal. It's a Federal Reserve districts. They've created a private jurisdictions, and you have a Federal Reserve Act. They've contracted with Article 1 of the legislature, which is Congress, and now that's why they put together these banking. All these banking associations are members. They're member branches of this private organization. This is what you got to understand. This is why you need a social security number. This is why they're always asking you for a social security number for everything, because you have to have proof that you are a United States citizen, all right, which is evidenced by your social security number, and that allows you to operate in that private territorial jurisdiction of Congress. Now, That is also the reason why you're sending information to the Treasury Department, because you're putting them on notice. Everything we do is notices. You're putting them on notice that you're going to be utilizing your account for set off purposes, and you expect them to honor HGR 192 of June 5th, 1933, Public Law 73-10, and all associated policies. You're giving them a bond. The windfall of any interest or any investments of that bond is going to go on fiduciaries, and fiduciaries have to be receive some sort of remuneration for their services or payment, money. All right. So understand all these things. Once you start getting into this, you understand that what you're doing in essence is private banking. You're setting up a private banking account. There isn't any money. Everybody's using debt paper. You as well can use debt paper. However, you have to have permission to use debt paper in a private jurisdiction. That's why a lot of people get in trouble, because they think they can just arbitrarily and capriciously start putting together promissory notes, and without doing any type of secure party process or anything like that, and just start shooting instruments to someone. That's why step one of our process is that we notice the federal government and give them 30 days to rebut anything that we're saying. All right, we're letting them know this is what our intentions are. All right, that way we negate any accusations about mens rea or criminal intent. We told you what we were going to do. We gave you a list of the negotiable instruments we'll be utilizing along with all those numbers. All right, we informed you how we would be routing those instruments, and we gave you an opportunity to rebut anything that we were doing by demonstrating in law how we did not have the authority to do what we're doing. A lot of times the government, they bankrupt, they debtors. Beggars can't be choosy. Hell, they get all excited when you give them a bond. All right, you write your signature on anything, everybody gets excited, because that has value. It has commercial value, because a living, breathing man or woman capable of performing labor is guaranteed to act as a guarantor or a surety on an obligation. I hope I'm not losing nobody. I'm looking for the comments. Comments ain't on here, y'all, so I don't see